Welcome to The Explainer. Today, we're going to break down something really fascinating, India's new evidence law, the Bhartiya Sakshya Adhiniyam. We're going to look at how the legal system actually figures out what's true and what isn't.
I mean, think about it. This is the core problem for any court, right? You've got two people, two completely different stories. One says this happened, the other says, no way, that didn't happen. So how does a court cut through the noise and decide what the facts actually are?
Well, it's not about gut feelings or just picking the story that sounds better. The whole process is guided by a very specific rulebook. And this rulebook defines exactly when a court is allowed to say, okay, we consider this fact to be established. It's way more detailed than a simple yes or no.
See, for any fact that's brought up in court, it doesn't just get sorted into a true pile or a false pile. The law gives us a third, and honestly, a super important category for when the truth is, well, just not clear. And that middle ground is absolutely essential for making sure the system is fair. All right, so let's break down these three possible outcomes. A fact can be proved, meaning the court is convinced it's true. It can be disproved, meaning the court is sure it's false, or it can land in that vital third space, not proved. Now here's what's really cool. How does the law define that level of belief? It's not about being 100% certain, because let's be real, that's almost impossible. Instead, the law sets a very practical, real-world standard for what it means to be convinced. So the law basically gives a court two different ways to get to a proved verdict. Path number one is the direct route. The judge looks at all the evidence, the witnesses, the documents, maybe some video, and just straight up believes the fact exists. Simple enough. The second path is what's called the prudent person test, and this one is all about probability. So who is this prudent person? Well, it isn't a real person. It's more like a legal standard, a hypothetical, totally sensible person who just uses common sense. The court has to ask itself, based on everything we've seen, is it so likely that this fact is true that this reasonable person would bet on it in their own important life decisions? If the answer is yes, then the fact is considered proved.
Okay, now for the really crucial difference. Disproved versus not proved. Disproved is an active conclusion. It means the court has looked at the evidence and is confident that the thing did not happen. But not proved, that's totally different. That's the court basically holding up its hands and saying, look, we just don't have enough to go on here. It's a vital safeguard that prevents a judgment from being made when there's just too much doubt.
And this simple example just hits the nail on the head. Imagine someone accuses you of slapping them, but you were the only two people in the room. No witnesses, no cameras, the accuser can't prove it, but you can't really prove a negative, that it didn't happen. So the allegation just hangs there in legal limbo. It is not proved. So, if a case can just get stuck because there's not enough evidence, how does the system keep things moving? Well, to make things more efficient and sometimes more fair, the law uses these things called presumptions. Think of them as legal shortcuts or starting points that help manage who has to prove what.
You can think of these like default settings. When certain basic facts are shown to be true, the law sometimes tells the court, okay, you can now assume this other fact is also true, unless someone proves it's not. It's a huge help, so we don't have to prove every single tiny detail from scratch every single time.
But here's the thing. Not all presumptions are the same. They're not all created equal. They actually exist on a spectrum of legal power, from just a gentle suggestion to an absolute unshakable command.
So first up, we've got the most flexible one, may presume. With this, the law is basically just giving the court an option. It says, hey, based on how things usually work in the real world, you may assume this fact is true. But it doesn't have to. The court has total discretion.
Okay, now things get a lot more serious with shall presume. This is not a suggestion, it's a command. The law directs the court that once a certain fact is proven, it must presume another fact is also true. The judge has no choice here, and the responsibility, the burden of proof, then flips to the other side to try and disprove it. And finally, we get to the top of the pyramid, the most powerful one of all, conclusive proof. When the law says one fact is conclusive proof of another, that's it. Game over. The court accepts it as final, and no evidence, no matter how convincing, is allowed to be introduced to argue against it. It's a line in the sand.
And you can see this really clearly right here. With may presume, the court has a ton of freedom, a high level of discretion. But that freedom drops to zero with shall presume, because the law is calling the shots. And with conclusive proof, well, discretion isn't even part of the conversation. It's an absolute rule. Let's break this down with some examples to make it super clear.
A may presume situation could be a simple property dispute, where the person making the complaint still has to do most of the work to prove their case. But then you look at a shall presume case, like a very serious allegation of a dowry death. The law recognizes how hard it is to get direct evidence, so it shifts the burden onto the accused to prove their innocence. Now, both of those are rebuttable. New evidence can still change the outcome. But conclusive proof, like the rule that a child under 7 is incapable of committing a crime, can't be argued. It's final.
So, after looking at this whole framework, the 3 possible verdicts for effect, and these 3 different types of legal presumptions, it's pretty clear the law isn't just a simple search for the absolute truth. It's a highly structured process for reaching a logical conclusion. Which brings us to the big idea: justice.
And that's really the big question we want to leave you with. This entire system, it's a very organized quest for truth, and it's all designed to create consistency and fairness. But by setting these rules, by deciding when to presume something is true, and by defining what level of proof is good enough, the law itself is making choices about what justice looks like. And understanding these rules, well, that's the first step to understanding that choice. Thanks for joining us.